Hello, everybody, and welcome to our webinar on the flexible working regulations and the flexible working bill that has come in recently. I'm really excited about this webinar, and I'm hoping that all of you can hear and see us. If you could just drop in the comments that you can hear me all right and see us okay as well, that would be fantastic, just so that we know that we don't have any technical issues, which we have done in the past. But fantastic. Thank you very much, Kath. So here today, I've got Dean Jones, who is the founder and managing partner of Jones Chase Employment Lawyers. So many of you will know, if you've been to our webinars before, that we tend to have kind of a bit more informal, very opinion-based webinars and discussions about different themes. Whereas actually, I'm really excited about this one today because we're going to be focusing on lots of cold, hard facts. And I know from discussions with many of our clients at Flexa that the new flexible working regulations have created a little bit of nervousness and a bit of uncertainty around exactly what companies need to adapt to, but also from a individual basis of exactly, what are your rights now? How has that changed? So really looking forward to chatting with Dean. Dean, would you like to kind of introduce yourself? I've obviously given a bit of an overview, but it'd be lovely to hear from you.
Yeah, that's great. I'm losing my voice is the first thing, just to get out there, just perfectly timed. So I'm Dean. I'm the founder and managing partner of Jones Chase. I set the firm up 9.5 years ago. We have a 10th anniversary coming up this year. Just briefly, we act for, which I'll come on to later, importantly, both sides of the fence. So 50% of the business is acting for companies, the other 50% is acting for employees and workers, which is highly relevant to what we will discuss today. We're also the first employment or first law firm to be flexified by your wonderful organization. So very happy with that. Practice what you preach. So flexible working is at the very core of Jones Chase. It sort of has been from day one. Our clients always come first, but it's about finding ways to balance both. And maybe we'll discuss that later as well.
Yes, absolutely superb law firm, both flexified and very much do practice what they preach. But also we work with them as well and cannot recommend highly enough. Just before we kick off, some brief housekeeping. So I'm sure that there'll be lots of questions and we want to make this as sort of interactive and workshoppy as possible. So we'll be having about 40 minutes of discussion and then I will leave about 20 minutes at the end for questions. So if you'd like to ask a question, it can be super specific, don't worry about it. You'll see on the right hand side, kind of next to the chat that's going on, there's a Q&A button. If you could pop your questions into there, then we'll come to them at the end in the final 20 minutes. Please do feel free to kind of add stuff into the chat if you're have an opinion on something or you really agree with something. And then kind of secondly, we always offer to our webinar guests to be able to benchmark your flexibility against the current markets. And I think this is particularly interesting in the context of this discussion because the more flexibility that you're offering upfront, the less the likelihood that you're going to have lots of requests to change and to have more flexibility. So if you're interested in how you're ranking against your peers, then click that little green banner at the bottom. So I think probably the best way possible to kick off is, what are the key changes in the recent flexible working regulations that employers should be aware of?
Yeah, thanks for that, Molly. Just getting right into it though. There's six main changes. I'm sure most people on the webinar are familiar with the statutory flexible working regime. So I'll just run through the six of them. The first one is that from the 6th of April this year, employees can obviously request flexible working from day one. You no longer need to wait for 26 weeks. Secondly, employees can make 2 formal requests for flexible working under the statutory regime in any 12-month period rather than just one. Thirdly, the flexible working process now needs to be concluded within 2 months, which is down from 3 months, including any appeal, unless there's an extension agreed. Fourthly, employers must consult with the employee in question if they are going to reject a request. So this is new, and there was no obligation on an employer to consult prior to this, believe it or not. Number 5, the requirement that employees need to explain what effect, if any, they thought their requested change would have on the employer and how any effect can be dealt with. That's been removed. So when you're making a flexible working request, you no longer need to explain that anymore. in accordance with the statutory regime. But personally, I think it's a good thing to do anyway, because the more information that you give, the more likely your request will be granted, hopefully. I'll come on to that in a moment. And last but certainly not least, point number 6 is that there's now a new statutory ACAS code of practice, which tribunals are required to take into account when dealing with claims or deciding employment tribunal claims. So employers should be aware that they not only need to comply with the new law, but they must have their minds on complying with the best practice provisions set out in the code, which are more extensive, and the code does place a greater burden on employers. So without at risk of speaking too much, I just want to mention a couple of extra things, just a few points to add, Molly, if that's okay. It's just to kind of highlight that the changes here are to the statutory regime only. There's nothing stopping employees and employers from doing things informally. For example, you can make more than 2 informal requests in 12 months. It's often much quicker to deal with things informally as well. Secondly, also worth remembering, the statutory regime applies to employees only. It doesn't apply to other types of worker, like freelancers, consultants, contractors, agency workers, self-employed. But employers should be aware that other aspects of employment law, such as the Equality Act, do apply to these workers. So just be careful if you reject things out of hand. I'm sure people on this webinar wouldn't be doing that, otherwise they wouldn't be here. And lastly, and again, we discussed this prior to doing the webinar, Molly, and I did say I always wanted to add as much value for your business contacts and people attending the webinar as possible. So I'm going to be sharing a bit of inside information as well. Whilst the statutory flexible working regime is quite weak, I think everybody thinks that, and it's not news. What everybody may not know is that it sits on top of a truly vast body of employment law. And prior to coming on the webinar, I thought about how many other aspects of employment law or other law are kind of wrapped into flexible working, not just the statutory regime. Just to give a quick list, it can cover, I think how many on the list I've got, 10 to 12 things. It covers sex discrimination, direct or indirect, age discrimination, disability discrimination, religion or belief discrimination, constructive dismissal, stress at work, mental health issues, personal injury, health and safety issues as well. And we'll come on to this a bit more, but all of this is kind of sitting under the statutory flexible working regime. And I think it would be good for people on the webinar to probably understand a bit more about that as well. So we'll come on to that.
Definitely. And I think that's a really good point around sort of all of those other areas of employment law. And like ultimately that comes down to sort of as an umbrella term, like the inclusivity of working environments. And I think that's one really interesting thing that quite often isn't being considered when we think about this change in flexible working regulations and law. So I am a relatively opinionated about the matter. I actually don't think that mandating from the top is ultimately going to change business behaviours enormously. There was obviously previously the right to request it at 26 weeks, and there have been changes and there has been progress in the right direction. But ultimately, if you're in the position of looking for flexibility, needing flexibility, and you've mentioned many reasons that somebody might need that, whether that's because of caring responsibilities, because of having a disability, because of having certain, neurodivergent individuals, chronic health conditions, whatever that might be. If you need flexibility in order to thrive, it's quite difficult to be put into a position where you accept a job offer, but you don't know until you've actually made that request whether that request is going to be granted, which is why I always advocate for companies being very transparent with exactly what their preferred working environment is, saying, we tend to operate a hybrid working environment, 3 days a week in the office, 1 day a week in the office, 1 day a month in the office, or fully remote. I think companies being as transparent as possible, and therefore being able to hire aligned talent that wants to work in those ways is like ultimately the most sensible and logical thing to do, because you're going to attract people that are our culture add and are going to thrive in the working environment that you have, rather than having to do a 5 days a week in the office and then make all of these exceptions for people. And I ultimately don't think that this will change business behaviours enormously, and we'll come to it a little bit later, but the consequences of potentially not doing everything right are not enormous. So I think it is in
Come
just
on to
within.
that in a moment. Yeah, yeah. Just under the statutory regime. This is why it's good to have this discussion, just sort of raising the awareness of the
Exactly.
wider issues. Yeah, yeah.
Yeah, and obviously it comes into a much wider framework. But I do think it's interesting as to why that transparency is so important, and embracing flexibility from before day one, letting people make that decision before they've even considered applying. Obviously, that's why we started Flexer. It's why we work with all of these businesses that offer amazing flexibility, and we showcase them in order for them to hire that aligned talent. But I'm not an enormous believer that this will make a big difference when it comes to the acceptance of flexible working in society. I feel like it's a little bit like forcing a child to eat its broccoli. I think these companies will feed that broccoli to the dog when the parents aren't looking. So we'll come to some of the reasons that might happen shortly.
That's a great analogy, by the way.
Yeah.
I do like that.
So first things first, obviously, a lot of the people listening will be wanting to abide by the law and make sure that their organisation can ensure that there's fair and consistent evaluation of flexible working requests. So, how can organisations handle these requests in the best way possible?
Yeah, I think the most important thing in 2024, well, since the 6th of April, is that employers should now, because it's enshrined in the new ACAS code. I think there's a lot of good things in the new ACAS code, by the way. I fully understand your point completely about, and sorry, just to say, I looked like I was disagreeing with you earlier. I really wasn't. You're totally right that the statutory flexible working regime in itself isn't strong. The maximum compensatory amount, if you breach if an employee breaches it, it's £5,600. It's not a great deal. But what most people wouldn't understand, and maybe it takes a specialist employment lawyer like what we do in Jones Chase to explain these things and to broadcast it, is there is this huge body of law which we'll pull in today. But just going back to so I do agree with you, but we'll add to that as well and give some helpful pointers. So yeah, in terms of things that what employees need to do now to comply with the new law, call it, is that first of all, I think the most important thing is employees now really should approach the issue of flexible working and flexibility with an open mind. It's enshrined in the new ACAS code of practice, and ultimately, I think it's in page 2 of the forward ultimately, and employers really now, even when designing job descriptions, need to think about how can this be done flexibly right at the outset. It also encourages employers to be more upfront about flexible working arrangements at the interview stage. I think you would know way more about this than I would, but ultimately employers that advertise flexibility as part of their job adverts get a 30% increase in applicants, I think. So people are looking for this as well. Yeah, so the first thing is to approach things with an open mind. Secondly, I think there's really no excuse for not complying with the new law. So I think companies, managers need to familiarize themselves with it. The ACAS code of practice, only 6 pages long. It's quite a quick read, So I think the code for the Equality Act is maybe 500 pages. So 6 pages, we'll take that. It's got some good things in there. So definitely have a look at that, because when you're dealing with flexible working requests, the tribunal will be looking to the company for compliance with the best practice principles in the code. And there's some good things in there, like I said, as well. And yeah, maybe just to list some of these. As before, you have to deal with the request in a reasonable manner. That now involves consulting with the employee, but specifically in the code as well, there's an emphasis on looking for alternatives. So just saying no isn't good enough, and I think it's paragraph 17. There's a lot in there as well as paragraph 24. Paragraph 17. That's where you've got to look at which parts of the request can work and which parts can't. It mentions trial periods as well. There's an emphasis on finding a solution. A couple of other quick things. I think employers shouldn't go for purely technical points. The tribunals won't like that. So if an employee doesn't say, this is a statutory request under the flexible working legislation, and the employee just ignores it and rejects it, that will not go down well, and it won't defend you from a potentially far more costly discrimination claim as well. And yeah, so I think just basics, training managers on the new law will be good as well.
Yeah, it's clear that there's obviously a lot to bear in mind when you're thinking about handling all of this fairly and not opening yourself up to sort of further claims that are outside of, as you said, the just over sort of £5,000 consequence of this. And I think it also, to come back to the previous point that I think we sort of both made around making sure that your whole hiring process is inclusive and equips people with as much information as possible up front, rather
Yeah.
than leaving it all until this request point. And, at Flexa, we advise a lot of companies on how to make their hiring processes as inclusive as possible. And so it would always start at how you advertise and market your company as a great place to work. Phrases like "we're open to flexible working" just don't cut it anymore. What does that actually mean to somebody? Because I think even this concept of a flexible working request, right? It can encompass lots of different things.
Mm-hmm.
It can be the hours that you're working. It can be the working pattern that you have. It can be the place of work, as in like where you actually predominantly do your work from. So being as clear as possible as an organization, and I know lots of companies don't have just one homogenous way of working. It might vary between teams, or it might be at manager's discretion. But I think trying to come to some form of overarching framework as to what your company supports, whether it's hybrid, whether it's remote first, whether it's core hours and people work around that, or is it really set hours? And being as upfront as possible from the very beginning in your employer branding, in the way that you write job descriptions, in your careers page, so that information is as freely accessible as possible. Then moving that through to that kind of application stage, making sure that when people are clicking through and actually applying to roles, that information again is accessible and kind of at hand. Like, we have our flexible working ways of working available at pretty much every single step of the application process. And then when we also speak to somebody at interview, we have a discussion about how they like to work. And I think that's really important when we think about inclusive hiring and think about helping people to understand whether your company is the right fit for them. And then finally is obviously when that offer is made, ensuring that they're happy with that way of working, with that pattern, if any adjustments need to be made, and trying to foster and open those conversations all along rather than just leaving it until day one. So I think there's so many different ways that companies can soften the impact that this regulation will have without actually, having to even get to these day one requests. There's a lot you can do beforehand. And as I mentioned, helps you attract that aligned talent. And you correctly mentioned there that companies that say about their flexible working do get 30% more applications. And being honest about it, I think, is super important. I talk a lot about this idea of like flexible working catfishing, and it's happening a lot at the moment. So I'm sure everybody has seen on LinkedIn companies saying that they're remote when actually they're expecting people to be on site a couple of days a week, or some saying that they're hybrid, but really that's like work from home if you have a doctor's appointment. And recently, when we looked into the proportion of companies that were saying they were remote, it was 68% of companies said that they were, and only 18% actually were. So there's a massive kind of damage of trust between candidate and company, and that is only going to exacerbate the number of flexible working requests that happen. If somebody believes that they're buying into a flexible company, then they land there and actually it's not remote, they're in the office 4 days a week. So I think honesty at this point is definitely best, because naturally there is cost involved with dealing with all of these request processes correctly. And then if it goes further and you do need the help of employment lawyers as well, it is naturally more expensive. So there's a logical and sensible way to try to mitigate the impact that it's going to have without even having to get there yet.
Yeah, that's right. And just to add to that as well, sorry to cut you off. Sorry.
No, carry on.
Yeah, I think just to add to the point about recruitment, is what we're discussing today is the statutory regime. There's absolutely nothing stopping an employer or an employee or a worker discussing flexible working at the interview stage. And I think you can have a horrendous mismatch if you're not honest. I think to be clear is to be kind with people. So I think an employer really should be thinking about flexibility when hiring, and let people know in reality what's actually going to happen. And yeah, even though the statutory regime's triggered on day one, I mean, just, it's a common sense approach. If you need to discuss flexible working with an employee, people coming in, why not do it at the interview stage? It makes sense to me, because you just want to get the right fit. It's incredibly expensive if you don't. And I did say this is going to happen. I need to turn the lights back on. Can you just bear with me 30s? I did say it was going to happen, didn't I?
Go for it. The lights are on a timer there, and so Dean is just sitting in the dark. So as we go through, I can see that no one's put any questions in yet. Please do feel free to do so, or you can just pop it in at the end if it hasn't come to you yet. So, Dean, I think we've talked a lot about the changes and what companies need to do, and to add a little bit of scaremongering into this. So, what's the kind of potential risks and pitfalls that employers should be aware of when they're considering this? Like, what's the worst that can really happen?
Yeah, okay, well, that's a great question to ask a lawyer, isn't it? I think we're going to go for the doomsday approach with everything that we look at, including my personal life as well. I'm trying to rebalance that. Yeah, even though, as we've discussed, the flexible working regime is weak in itself, and the maximum amount, the tribunal can only look at certain things as well. It can't really get behind the commercial decision that an employer, there's 8 statutory grounds that they've been in place for a long time that employers can use to reject flexible working, and the tribunal under the flexible working regime can't really get behind the employee's decision unless it's made on false facts. Okay, but even then, if an employee brings a complaint under the flexible working regime, then the maximum compensatory award is it's 8 weeks' pay, and that's capped at £700 a week, so only £5,600 in total. But what we sort of did want to mention today as well is that sort of 50% of our business is acting for individuals and claimants, and so this is good information for the trailblazers out there, and for those companies out there. We've got a number of company clients as well. I'll come on. You need to listen to what I'm saying in the reverse, if that makes sense. But we know how to defend these types of issues as well. But dialogue is hugely important, and just speaking to people and getting stuff out right up. It's been really upfront, and keeping an open mind can help to avoid claims. A large part of what we do is trying to stop claims from happening for companies. In terms of acting for employees, we are the exact opposite. We are as difficult and belligerent as possible. And so with that in mind, if you're looking to trailblaze or to create a change within an organization, when we act for claimants, individuals who need flexible working, it could be for childcare reasons, they have a disability. One of the first things we do in Jones Chase is to look to see whether there's any statutory claims whatsoever that we can use to support the application. And then we would deliberately write information that relates to these claims into the flexible working application itself. Normally very much gets the attention of HR and legal on the other side of the fence, with the view that if the request is then rejected, they know there may be a claim coming, but ultimately then they may just approve the flexible working request rather than not. So the quality of the request in itself is hugely beneficial. And again, there's a huge list of things that could be relevant. So for working mothers, particularly indirect sex discrimination, that claim can be brought by men now as well. If, for example, a company would typically grant flexible working requests for working mothers and a father doesn't get one, that could be, believe it or not, a direct sex discrimination claim brought by a man against the company. Age discrimination, disability discrimination, there's a statutory right for a disabled person to have reasonable adjustments made by the employer. Indirect religion or belief discrimination, if the employer just doesn't deal with the request properly or at all, or just kind of fobs it off, there could be a constructive dismissal scenario if people have got more than 2 years service. Where people don't have a statutory right to bring a claim, stress as well is something we've used successfully for a lot of people, is to say, my current working arrangements are causing me significant amounts of stress. Therefore, I require the following flexible working arrangement because it doesn't fit with my evening classes, so nothing to do with the typical working parents. Stress can be used as well. Health and safety, even though you can't directly bring a claim of health and safety, it's enforced by the government. A lot of companies would be very nervous about allegations of work-related stress, mental health issues, and health and safety generally. And a lot of these things are very real for people that come to us, and by the time they come to speak to us, they're in a pretty difficult position. They really need the flexible working request to go through. So it's about making the request as dynamite as possible, using as much law as possible, not just the regime. And then for companies, um, just to answer it in the other way, to be more balanced, when we act for companies dealing with flexible working applications, if they genuinely can't be done in the way that the employee wants them done, it's all about evidence, evidence, evidence. You just have to be able to, certain types of discrimination can be objectively justified. Um, I think we do act for some cases where the managers, well, no, 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 it just can't be done. Just can't be done. Well, why not? It just can't be. When you start to cross-examine your own client, well, please tell me why, and then they crumble. So that's a case you then need to settle, obviously. But for companies, it's all to do with just really getting the evidence in place to support the company's position, and employers can say no as well.
Yeah, that's exactly it. And I think actually something that we haven't touched on that might be useful both for individuals looking at, you know, potentially making a flexible working request, but also companies when they're understanding what they're dealing with. What kind of thing can go into a flexible working request? Obviously, I mentioned before around like hours or working patterns or places of work, but like what can people request?
Or in terms of what arrangements generally, or
Yes.
what should they put in the request to go through?
What could go into a day one request?
Sorry, it just cut out then. Sorry, Molly. In terms of the working patterns.
Exactly. Yeah. Could it be hours, location? You know, what kind of thing could employers expect to see?
Yeah, the statutory flexible working regime applies to hours of work, location of work, and the time of work.
Yeah.
But I mean, to the extent there's any more than that, I can't think of one.
Yeah.
But dealing with things informally, of course, includes everything conceptually, that you could possibly conceive of. And I think so. A flexible working arrangement really can't be anything that you can think of. There's no limits on it as such. And then,
Yeah.
as I discussed, in terms of what should go into the request itself, you need to explain. Well, I'm a big fan of dealing with things informally first. That's how we've dealt with things in Jones Chase. And if one of the staff presented me with a formal, flexible working application, I think, did you not want to discuss this
Like,
first? But
yeah.
yeah, I mean, well, there's no need for that. But we're here. But ultimately, yeah, I think if you're writing the request, you need to put the arrangements in. If it's going under the statutory regime, you need to say as part of the statutory request the date that you want the working arrangement to take place on. As I've already mentioned, any statutory underpinning, put that in as well, more likely to get approved. But also, even though the requirement has been removed from, there's no obligation to put in the request how the employee thinks it can affect the business and ways to mitigate it. I definitely think you should put that in anyway, because being upfront about these things means that it's addressed at the outset rather than maybe by way of an appeal. There's no statutory right to appeal, believe it or not. So put everything in that request as much as possible. I think is the best thing to do.
Yes, exactly that. And I think that informal approach at first is definitely the right way to go.
Yeah.
What I think is very, very interesting, and I bring kind of my own personal experience of this, although it was back in 2017, so very much the old regulation rather than the new one, is I was invited to make a flexible working request in order to accommodate my autoimmune disease, where my feet swell up, my hands swell up, my face swells up. Like it's not really something you want to go into an office with, but I can work from home very easily when that happens. And I'd been with my employer of a few employers ago. I cannot name them for good reasons.
Probably best. I don't know. Probably best not. I don't know who it is, but probably best not to. Anyway, yeah.
And I'd been there for 18 months, and they said, well, you can request to work from home one day a week, and sent me to an occupational health therapist to assess me to make sure that everything was legally sound and that I was telling the truth. And that occupational health therapist recommended that I be registered as disabled. So this is where all of that other employment law that you were talking about starts to come in, right? So when I did ask to work from home one day a week, that request was denied. But I was sacked immediately as well. And the consequences of that financially, it's not in the £5,000 remit at that point. So obviously they did offer me a settlement package and I worked with employment lawyers, but the sum that they had to pay me to get out of the potential legal repercussions of that situation was significantly higher than £5,000. So I do think that, when you're thinking about these changes to the regulation, you're totally right in pointing out all of the other underlying employment law, because the likelihood is that if somebody has requested flexible working and they've given their reason for it, they probably do fit into another one of those buckets that can claim discrimination. And that is then a much lengthier, much more costly and much more involved procedure to get rid of that. So
It's an incredible story. Wow.
yeah,
I'm
it's
just thinking of all the potential claims that you've got, or automatic unfair dismissal being one of them as well. So,
yep,
yeah,
unfair
if you
dismissal,
request,
disability
yeah, yeah,
discrimination, sex discrimination, all sorts.
wow.
It was very interesting. I was only 23 as well, so I had no idea what was going on. So
Sorry to hear that. Yeah, yeah.
yeah,
But
mad.
it's led to you setting up your company, which is great.
Exactly that led to Flexa, where I just didn't really want that to happen to anybody else, and also how difficult it was to find companies that would let me work from home 1 day a week. It was absolutely blew my mind at how difficult it was to find companies that were leading with transparency, because it really wasn't the norm back then, and sadly it isn't really the norm now. So perfect segue into our other question, which is, around how organizations can foster a culture that supports and embraces flexible working. Because this, if you're thinking about all of these requests, which is one of the reasons that I don't love this regulation, is if you have, say, 2 or 3 people in your organization that have requested to work flexibly and everybody else does not, they all work 9 till 6, they're all in the office 5 days a week, those people that are working flexibly are very likely to be treated slightly differently. Whether or not that comes through in any legal discrimination ways is another matter, but culturally you may be seen differently, treated differently, likely to feel othered. And I definitely found that when I was one person working flexibly in other organizations when everybody else didn't. So I think it's very important for, again, companies to adopt flexibility as the norm. There are so many different reasons that this is a brilliant thing to do. I can point to the fact that, I mean, in the UK alone, more adoption of flexible working being the norm, would add 80 billion to the UK economy, which is crazy. It would enable over 1 million people with disabilities to get back into work because they don't have to go into a physical office. It would enable women to balance both being a mother and also being able to work a proper full-time role rather than often having to sacrifice working because of the cost of childcare. It would also help massively with economic wealth distribution into rural areas as well. There are so many different benefits that are both economic but also social. And so I think from companies' perspectives, what are the important parts of it? And at Flexa, we verify every company's flexibility. James Chase scored brilliantly. But we look at 6 different areas that we think are really important when it comes to fostering true flexibility. And it's not just about location or hours. Obviously, those are the ones that you can request. But there are other bits that really go into it that are super important. So when we start off verifying companies' flexibility, yes, we do focus on location. Do people have some location freedom? And to put some sort of colour on what that means. At the moment, the market sort of average is people going into the office 4 days a week. So anything above that is very good. And hours wise, we also measure, do you have hours flexibility? So those really, really set hours where people give you funny looks because you've come in at 9:03 rather than 9. That's not flexible. Companies can have a half-hour flexibility, core hours, totally asynchronous if you've got employees all over the world. But then as you start to go outside of that, you've also got benefits flexibility. So there are lots of benefits that really add to the experience of flexible working within a company. If you've got a dog, and I've got my dog fast asleep next to me there. If you've got a dog, then having a dog-friendly office, not having to put them into doggy daycare, you're able to walk them. That adds a massive amount of flexibility to their lives. If you have children, then additional annual leave or enhanced parental leave, or if you're trying to have children, then adoption leave, fertility leave, whatever those things might be. So there's a plethora of benefits that really adds to that employee experience as well, that can really help in fostering a really inclusive culture. But then there are 3 sort of softer, more cultural areas that we see as being really important to fostering a flexible working environment. But that is trust and autonomy, that you're trusted to do your job well, you're measured on output, not hours, and you're given autonomy to be able to work in the best way possible to get your job done and perform. There's senior leadership role modelling. Are the people at the top actually working flexibly too? I think that's actually one that's quite often overlooked. If you've got senior leadership in the office 5 days a week working 12-hour days, people are not going to feel like they can work flexibly because it's going against the top-down culture. And then the final one is work-life balance, integration, whatever you might want to call it, because you can have all of the location flexibility benefits added on top and trust and autonomy, but if you're working constantly, you're not really going to be able to experience flexibility. And as both of us have founders, like we've probably experienced that at times as well, where we've just felt like our
Not
life.
entirely easy. No.
But for your
It's
employees,
great fun though. It's great fun, yeah.
so those are the 6 areas that we really measure and we really think are very important when it comes to fostering a flexible culture. But from your experience at Jones Chase, what do you think companies can be doing to foster truly flexible cultures and therefore hopefully reduce the number of flexible working requests that will come down the line?
Yeah, I think it's interesting because I guess what we're talking about was the 9 to 5 was invented in the 19th century, and I think human beings are creatures of habit, and I was guilty of this as well. Prior to the lockdown, prior to the COVID pandemic, we were coming in 5 days a week because that's what everybody did. And I didn't even. I mean, even though other people in the firm were working remotely, I just had a very rigid mindset, which leads me on to say I think great organizations such as yours are really raising awareness. And I think a lot of, I'm not sure if you agree with this or not, but I think change does need to come from the top down. And it
Absolutely.
looks like, yeah, I mean, the government aren't going to legislate for this by the looks of it anytime soon. So company culture comes from the top down. So senior management really needs to create a positive culture around flexibility. And then raising awareness of the benefits of flexible working. In the last 10 years, this has grown significantly. It was previously, comments, only working mothers did this or something. We had enforced flexibility because of lockdown, and that was done incredibly quickly. I think the Prime Minister said, if you can work from home, you should. And on that day, everybody in Jones Chase did. So that happened super quickly. So I think things can be done a lot more flexibly than people actually realize, and is getting rid of that rigid mentality. No, we can't do it. And I think, as you've said, keep raising awareness and just facts and figures of the profound benefits of flexible working and how that can benefit an organization. To balance that out, not every job can be done flexibly, of course. Being a law firm ourselves, the needs of the clients are absolutely paramount, always should be, and everyone in the firm's on board with that. But it's about being creative with solutions around that as well. And I think people can surprise themselves, but I think it does come from the top down.
Yeah, I think that's a really good point, right? So I think at least some of the people that I've spoken to about this change, I think they're a little bit fearful that they're not going to be able to say no. And I think that's a really, again, nice segue into the next question is, what if there is a situation where the flexible working arrangement that has been requested just isn't suitable for that certain role or that certain team? As you said, like you're a law firm, there is a level of kind of hours and presence that has to happen because your clients are going to come first. That's what gives you your jobs. Same as the work that we do, there is a level of kind of presence that you have to have and hours within a week that kind of have to be done. Being a startup, it's fast paced. There's only so many people that we have in order to be able to fill roles. So I think it's definitely not that companies can't say no to certain things. And I know that you'll go into much more detail, but I think it's more around the evidence that's much more important, isn't it?
Yeah, that's right. And I think we've touched on this briefly earlier, but to give the other side of the argument as well, if something doesn't work, the key thing a company should do is to get evidence to support that, rather than it's just an opinion. I mean, there's a lot of case law out there. People have been awarded, in certain cases, well over £100,000 worth of damages where things haven't been dealt with properly. So even if you get the one that we would write for a claimant, the nastiest possible flexible working request with so many allegations in there, you can beat all of them if the facts or the needs of the business truly require a particular working arrangement, because you can justify certain types of discrimination if it's a proportionate means of achieving a legitimate aim. You just got to get the evidence. Again, this is mentioned in the ACAS code, trial periods as well. So companies now really need to be thinking about running trial periods. I mean, personally, I think it can be dangerous for employers to run a trial period, because you're testing something that may not work. And I knew this would happen again. Sorry, but this will be the last time. I'll finish what I was saying first. Where a working pattern can put in terms of the trial period, you're basically saying, okay, let's give this a go. But when the problems then crop up, you may annoy some customers, which is never a good thing. It's then kind of getting the evidence to show that the flexible working pattern doesn't work. And then you've got something to defend any claims coming in with. However, what's really clear under the new ACAS code and under the new regime, this is really worth mentioning as well, is this big emphasis on being creative and thinking of alternatives and which parts of this can work and which parts can't. For example, you would think, being an employment law firm, you'd think we'd need to be here almost 24/7 sometimes, but ultimately job sharing is incredibly effective, and just making sure there's a base level of cover within the firm, doing the sort of 9 to 5 hours of the week. Certain people don't work Mondays, certain people don't work Wednesdays, certain people don't work Fridays. But if everybody didn't work on a Friday, one of our clients calls up and needs something urgently and there's no one to deliver, there's a huge problem. So it's about being creative with the solutions that you come up with.
Yeah, I definitely agree with that. And I think that makes complete sense as well. Like, there's lots of different things that you can try. And very rarely, unless you really do have to be in one place at a certain time all the time, very rarely there'll be no sort of compromise that can really be found. Super. We've got a few questions, and I just want to make sure that we've got enough time to kind of answer all of them. So we can always come back to our kind of previous discussion points afterwards if we've got a bit of time. But shall I let you turn your light back on, and then we'll come to some...
That would be lovely, because it does look a little bit odd and sitting in a dark room. So ironically, I'm in the office today, and then if I did this at home, then I wouldn't have these lighting issues. But there we go. There's a message there. Sorry, be very quick.
No, don't worry. So one of the questions that's come in that I can answer is they said, so there's been a great discussion so far, but if not off topic, and I don't think this question is off topic at all, actually, I wonder to what extent will flexible working laws entrench a two-tier workforce? Namely, those who can be afforded flexibility in terms of place and time, and those that can't, mostly frontline workers who are obviously critical to the running of society. How could and should businesses in teaching, transport, medical industries build in more flexibility? I think this is a really topical discussion, because I think one of the problems with the term flexible working is that it started to be conflated with and used synonymously for remote working. And while location flexibility is an incredibly important part of flexible working, it's not the only part of flexible working at all. I think the sort of argument of, we shouldn't offer flexibility because retail workers, warehouse workers, whatever, can't be offered it, is a little bit of a reductive argument, being honest. And I don't think that we should be thwarting the progress of a certain type of role just because of the fact that other roles can't be done like that. There's natural kind of difference of hours, conditions, working place of work, time of work, amongst so many roles in society. Pilots fly overnight. That's not something that I would want to do. I want to be working overnight. We don't force everybody to do that. And I think that comes back to a point that you made, Dean, about there's an expectation of what needs to be done in order to do your job well. So I don't think it's a good argument to use to say that flexibility shouldn't be, this flexible working regulation shouldn't come in and flexibility shouldn't be given. But I do think it raises a really good point around, how can businesses offer flexibility to those people that need to be in a certain place? And I think, when we look at the work that we do at Flexer, and we're starting to look much more at sort of frontline or blue collar work, for lack of a better term, and how businesses are offering different flexibility to those people and improving conditions as well. So some of the really innovative ways that we've seen companies do it is in many of those roles, it's hourly work, 0 hours contracts, moving away from that and starting to offer permanent contracts, paid holiday rather than unpaid holiday, much more flexibility in scheduling, shift patterns, hours, offering childcare support, private health insurance, time off to go to doctors rather than having to take that on your hours. That adds a massive impact and amount of flexibility to somebody's life. Companies like Mars are doing a lot of experimentation with their warehouse workers in terms of hours and flexibility around that, and holiday as well. So, and then from a teaching perspective, obviously they get half the year off in terms of holiday, so that's quite a big one. They get much more time off as well, and I think naturally there's an expectation that that can't be done from home. So I think it's important that we also understand that people know that they can't be working machinery from home, or maybe they can be in 100 years, but not right now. And that naturally we want to make sure that we're not just focusing on remote being the dominating theme of flexibility, but actually it's all about improvement of life. That's fundamentally what we're trying to do. Improve life, improve work-life balance, and improve conditions. And so I think that that can be omnipresent across all roles. I don't know if you would add anything to that, but that's my sort of rant.
No, that's great. I think that was a great list of things that you said as well. Employers can be creative, and like for example, you mentioned providing sort of vouchers for childcare, things like that as well. Um, Employers can create a two-tier workforce if they choose to do that quite easily, and some of them I've just seen in the press, not naming any names, making some pretty horrendous decisions. About rejecting flexible working applications or not considering them, things like that, which of course do not take into account, for example, disabled people or a whole host of other people with protected characteristics as well. So I think that the two-tier workforce, if employers want to fix that, they can. Also, it's worth mentioning from an employment law perspective that there is case law out there. And if I could remember the names of cases like I remember song lyrics from sort of 1982, then this would be very helpful. But of course, I can't right now. But there is case law out there where the tribunals have said employers must accept a level of extra cost when it comes to flexible working. So job sharing is huge as well. If you want to do that, so you can build flexibility um, in, into the workplace to reduce any sort of potential impact of a two-tier workforce. Employers have a lot more discretion about that than people may think.
Yeah, exactly that. And I think we just need to open up flexibility from beyond just remote working, because I think actually it's just ignores a lot of nuance within the discussion in the first place. So really interesting question from our audience. Is there a risk of triggering a discriminatory interview process claim if it's discussed at interview, as we suggested, and then that person that needed that flexible working then doesn't get the job?
Yes, there is, but I still think it's worth it actually, because if you don't do it, I think there's some surveys. It's on average, it's like a £50,000 plus cost to hire the wrong person, in terms of the hiring cost, salary, training somebody up, and then firing them, rehiring, and under drain and management time. So I'm a huge believer. Put my neck on the block here. Just get everything out in the interview that you need to. If you've got good reasons to reject that person, again, based on evidence, then even if there's a claim brought, you should be able to deal with it, basically. So, and I would say most people bring claims for again, 50, I'm probably more than 50% of my work is being claimant, but people tend to bring claims or to lodge grievances if they're upset. And as long as you take time to explain to somebody why a certain flexible working pattern can't be given with evidence, which is required under the ACAS code now, they're far less likely to get upset and look to bring a claim against the company. And also consider alternatives as well. We can't do option A, but what about options B, C, and D? And at least if you could be seen to be trying to make something work, you're far more likely to, assuming there is a claim, to defend it. 95% of our cases don't end up in a claim, I should add as well. I mentioned tribunal cases a lot, but a lot of what we do doesn't go anywhere near the tribunal.
That's a comforting statistic.
It may change after today, I don't know, but we'll see.
So another interesting question, and I don't know if you'll be able to speak on this at all. But are there any memorable issues that you've had relating to an employee having an issue around flexible working and their employer? Are there any cautionary tales?
Just so many, ranging from the most abhorrent treatment possibly imaginable, It wasn't me doing it, but the team dealt with a case in the last 2 years for somebody who became paralyzed. I think it was maybe a stroke. I can't remember the specific medical condition, but then wasn't able to walk, had to use a wheelchair, and then pretty quickly got fired because they couldn't come into the office. And so you see things as bad as that. The really strong bullish employer. So we did that
Yeah.
case and ultimately had a fantastic victory. And it means you go on this journey with people, and when they first come in, they're incredibly upset and everything's very stressful. And you have to say to people, okay, like, don't worry, we'll get you through it. And then there are still some pretty shocking employers out there. But when you get a victory for that person, whether it's a good settlement or a court, it just means the world to them, their family, and everyone they know. And I think with companies, a lot of cases can be quite procedural. It's one of a number of things they're dealing with. For individuals, this is essentially life or death, and that's all they think about. So yeah, there's too many cases to mention here without naming any names as well.
Exactly. There are, I've heard of some absolutely horrendous ones as well. Like somebody using their holiday after coming back from mat leave to kind of work part time, because obviously you accrue all of your holiday afterwards, which is quite
Yeah,
a normal thing to do. And then them being let go on the grounds that they were working part time, which obviously makes no sense at all.
no, no. Well, yeah. They probably, I mean, I think with the trial period, I should say as well, if again there's trailblazers out there wanting to instill change in their company, push for a trial period and then work so hard that you get proof of concept. You just show that it works, and then the employer doesn't have the reason to say it doesn't work. And obviously, since lockdown, it's almost been proven that the vast majority of things do work, largely. So yeah, there's a lot of evidence out there now that people can use to promote flexible working.
Yeah. So got another question here. So, is there a need for the employer to provide a home working setup, like a desk or chair or whatever it might be, for those who are working from home because they've requested that flexible working pattern?
I think, yeah, this is a health and safety question. I don't, it's a classic lawyer disclaimer. I don't deal with health and safety issues, but from my understanding, I think the strict position under the Health and Safety at Work Act and regulations are you need to do a risk assessment a lot of the time. So yeah, I mean, I would recommend ideally, hiring a health and safety consultant or maybe speaking to your insurers to see if they have anyone who can do a workplace assessment. And yeah, I think particularly if someone's having back trouble and they work from home, then ideally getting some equipment as well. But what you tend to find is if you agree things with people, like I said earlier, when the law firm here had to work, couldn't come to the office due to lockdown, people just kind of got on with it as well. But I would definitely pay attention to requests for equipment, and you can get a health and safety expert to help you. It's not expensive as well. And I think we've got some connections in the firm. If somebody needs to, you can outsource it to an expert, and it really isn't expensive.
Brilliant. Great advice. Thank you. Um, and another question here is, what if your company isn't set up technically to be able to support people from working from home? Her company isn't quite there yet, and she's concerned that this is going to cause some additional issues.
Yeah, I think again, this is about not upsetting people in the first instance. If you have a very open again, forgetting employment law for the moment, if you have a very open dialogue with your staff to say, hey, look, if you are trying to introduce this in the future, just give us 3 6 months. We've got these other existential crises to deal with first. Just give us a bit of time and we'll work on it. But what can we do in the interim to soften the blow? And just have an open dialogue with people and ideally get their agreement to certain things. And maybe don't commit to things that you can't do is important as well. But as with the new ACAS code of practice, it recommends just get a dialogue going. And if people feel they've been listened to and you're taking some things into account or there's some other workaround, it's best to go for that as well. Go for the line of least resistance now. But getting agreement to things is huge. It will stop grievances coming in or people going on sick leave and claims and things like that. Just get people on board with what you're doing until you get. And again, there's no legal obligation to going on the other side of the fence. There's no legal obligation to grant home working. Of course, if you have good reason not to do it, you don't have to do it. But just get the evidence to support that.
Yeah, it's all about evidence, isn't it?
Yeah.
I don't know if you know this case. I'd heard of it in passing. So there was a recent ruling for the FCA against a female manager who requested to work from home. This person asking the question said that's very disappointing. And I'm sure that was also disappointing for others working in financial services. But I guess, was it a surprise that that happened? And which other industries are behind the curve? I don't know if you know that case that happened.
I haven't actually read that one. No, I've been flat out dealing with other actual cases recently, but
Yeah.
I would imagine that in that case, always worth reading the judgments as well, which are available. The judges are normally pretty amazing at explaining things and just writing up the rationale um, why certain things have been done and the rationale for it as well. And which other industries are behind the curve? I don't sort of want to name drop, but I think um, I think that there are certain industries which traditionally are a little more old-fashioned as well. But like I said, lockdown hugely accelerated everything. I think the legal profession, for example, was pretty rigid beforehand, and all of a sudden, people realize, oh wow, you can actually lawyer from home. So things are changing as well. But I think where it's getting around this sort of concept that things can only be done this way or you must be present. And of course, at the moment, there's a big shift. Well, the tide is moving towards getting people back in the office, actually.
Hmm.
Not a lot of companies are doing that, and I'll be interested to see kind of where this ends up as well.
Yeah, those full return to office mandates are definitely happening. And to
Mm-hmm.
answer the question on industries, yeah, I would have said law firms about a year or two ago. But actually, there's been quite a lot of embracing hybrid work in particular, which I think is great. I think finance and insurance are still significantly behind the curve because obviously a lot of those industries that was built on relationships. Back in the 80s, you think of people doing their business deals, having a pint over
Mm.
lunch, many pints on a Tuesday. And obviously that can't happen from home. And so I think naturally finance and insurance are quite behind the curve. But what I do find very interesting with the FCA actually being involved in that is naturally one of the knock-on effects of not offering flexibility is that you are going to have an inherently less diverse workforce because a lack of flexibility is less inclusive. So
Mm.
companies that offer true flexibility are significantly more likely to be able to hire diverse talent. We see a 65% increase in diversity and talent pipelines when companies are on Flexer. So the FCA has now mandated and will be regulating firms on their diversity as well. So I think it's very interesting because you can't be regulating and checking in on the diversity of financial and insurance institutions without also thinking about the input, which is flexible working. So I find it
Yeah,
very interesting that the FCA were involved within that because that's a natural knock-on effect of flexibility as diversity. Super. Well, we've answered all
interesting.
of our questions, and it's 4 o'clock, which is perfect timing. Dean, thank you so much for joining me on this discussion. It's been incredibly informative. I've learned a lot, and really appreciate you spending the hour with us and taking the time to let us know about all of the amazing legal things and employment law that you know about.
That's great. Yeah, it's just great to see you, great to chat to you, and thanks very much for everyone for having me.
Brilliant. Cool. Take care, everybody, and thank you so much for joining us. Bye.